A landlord wants a tenant out, thousands of dollars in unpaid rent are hanging over the case, and emotions are already running high before the hearing even gets underway. But this isn't just about money. The tenants claim they've been living in poor conditions, dealing with constant stress, and desperately searching for a new place to live. The landlord says enough is enough and wants the eviction to move forward. As the hearing unfolds, accusations fly, tempers flare, and one unexpected courtroom outburst may completely change the outcome of the case. Stay tuned because what happens next leaves the judge visibly frustrated and forces a major decision that could determine whether this family stays housed or faces immediate removal.
Right at this moment, Your Honor, I've not heard from either one of them. They are still living in the home. I don't know that this matters or not, but they haven't paid rent. They owe rent in $5,700. We would like to continue with the eviction.
When was rent last paid?
Last rent was paid 9/26 of 22 for September's rent.
Mr. DeMille, what's your position?
Your Honor, my position is this. We have the money in an account. We're honestly not willing to give it to her because of all the things we've had to put up with since we were here. And I know that we do, you know, you pay what you owe. I firmly believe in that. But also, I believe in fairness also. And I also believe that she's been overcharging us. Like, okay, we did a lease when we first.
Stop. This isn't about payment of rent. She just said as an aside. They're attempting to terminate your tenancy.
Right. I understand that. And I'm okay with that. Oh, I'm sorry. Go ahead.
Are you guys prepared to move?
Yes, Your Honor. Like I mentioned last time at the hearing, we've been looking for a place. We've been looking for a place since we moved in here. We moved into very subpar living conditions. The rent's been going up. We haven't been having a lease redone. There was no agreement. She just upcharges the rent whenever she feels like it. She's fake evicted us 3 or 4 different times. Just the emotional stress over that. Like, we've had an eviction before. We know what it's like to be homeless, to be put out in the street. And it's really difficult when we get settled somewhere, like for somebody to keep holding that over your head when there's no actual proof or reason for her to do any of that stuff. She claims destruction.
We haven't gotten to that part yet.
Right.
But if you're willing to move voluntarily, then maybe we can.
Oh, I am, Your Honor, and like I mentioned at the last hearing, we've been actively and aggressively trying to move for at least the past year. Like, before she even tried to hit us with this, whatever she's hitting us with now, I can't even keep up. But we've been trying to move. We actually have been trying to move since we moved into this trailer because it is so disgusting and subpar living conditions. We've been trying to get out of here since COVID started. It's just been so extremely difficult to find a place, and we weren't trying as aggressively in the beginning of the year. But once all this started happening, we actively and aggressively we're trying to find some place to move. There's just simply no places to move, and the ones that are available, they want all these requirements that, like, she has an eviction on her record. So like back in 2018, which it's been a while, but they keep holding that over her head. And then, like, it's just been a number of things with the housing market the way it is, and there's no avail.
This is a critical turning point in the hearing. The tenant is now telling the judge that they have finally found a place willing to accept them, but there is one major problem. The new property won't be available until May 1st. That leaves a gap between the court's timeline and the tenant's housing plans. From a legal standpoint, the judge is weighing 2 competing interests. On one side is the landlord's right to regain possession of the property. On the other is the possibility of avoiding homelessness by allowing a voluntary move-out. Notice how the judge immediately starts calculating the dates and discussing what the law allows. This is often how landlord-tenant cases are resolved, not through dramatic rulings, but through negotiated timelines. What would you do in this situation? Should the tenants get extra time if they truly have another place lined up, or should the landlord be allowed to move forward immediately?
April 30th.
I defer to Chris on that. She can respond to that, Your Honor.
Well, Your Honor, I've always tried to be fair with my tenants, and although I'm not going to stand here and bash him the way he's been bashing me, it is not subpar. I have not raised the rent arbitrarily.
Okay.
We have put out newsletters as to when the rent was raised properly, the way we always have. He can sit there and say we haven't, and yes, I did put out an eviction prior to this one. I tried to work with them, but could you please stop?
The tension in this courtroom just exploded. While asking the court for additional time and understanding, the tenant suddenly walks away during the landlord's remarks, prompting a sharp response from the judge. This moment dramatically changes the tone of the hearing. Judges expect professionalism and respect from everyone involved, regardless of how emotional the case becomes. The judge reminds the tenant that they are asking for a significant concession, extra time to remain in the property, and that courtroom behavior matters. At the same time, the landlord begins detailing allegations involving property damage, disruptive behavior, and complaints from other residents. Whether those claims can ultimately be proven is another question, but the emotional stakes are clearly rising. Do you think the judge overreacted, or was the tenant's behavior inappropriate given the seriousness of the situation?
Asking for a consent to allow you to move out at the end of April, which is some grace, and then you disrespect me and her like that when she was speaking. If you were in the courtroom, you wouldn't get up and walk out and get a drink or go to the bathroom in the middle of the proceeding. So let her finish what she was saying. I'm not sure where we're headed for a hearing and a 10-day move out or a consent to the end of the month. Go ahead, Ms. Corpening.
Your Honor, at this point, I'd like to do a 10-day and a move out.
Well, then we have to take testimony, and we're going to have to present evidence regarding these alleged lease violations. Are you ready with witnesses to testify in that regard?
I believe that Chris Corpening has all of the relevant testimony, Your Honor.
All right, I've got somebody else here. All right, Ms. Corpening, would you please raise your right hand? Do you swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
Yes, I do, Your Honor.
All right, you filed a notice to quit with a termination of tenancy in December. The notice is somewhat vague, in fact, quite vague. It just says destruction of property. That's all it says. Seeking possession due to destruction of property. And then the complaint to recover doesn't tell me much either. So this is a very weak complaint. If legal aid was here, they'd probably make you file a motion to file a new one. What does that mean, destruction of property?
Your Honor, I have pictures of their child up on a roof. They climb the roofs, they break windows. Their child is not the only one who has done this, but I have evicted another individual who was involved in this as well. They're constantly walking in the middle of the road.
Let me stop you.
Sure.
You're not willing to give 17 days of grace. So, Mr. Bush, she's your witness. I'll let you ask the questions.
Chris, what is your position with Memory Lane Mobile Home Park?
I'm the property manager.
Okay. And are you involved with a tenancy involving Patricia Morse?
Yes.
And is that lot 173?
Yes, it is.
And that's located in St. Joe County?
Yes.
Okay. And as part of your duties, have you had to deal with violations of the rules and regulations?
Yes, I have.
And you started to testify before, but can you share with the judge what the major problems have been with the tenant and their occupants?
It's the disbehavior of the child. Him and a few other children have been climbing on roofs and breaking windows and disrupting other tenants. They were out with BB guns a while back. That has been a while, and that has since cleared up, but we've had them on roofs, we've had broken windows. They're just walking down the roads, flipping people off, no differently than Mr. DeMeo flipping me off every time he drives by. It's just, I don't feel like I need to
Wow.
tolerate that.
Well, all right, the complaint says destruction of property.
Yes.
I don't have it. I've got kids on roofs and alleged broken windows. So John, let's see if we can narrow this down as to when and where.
Can you
this
follow
happened.
up? Can you follow up on what property has been destroyed?
Meaning which lot numbers or what?
Yeah, I mean, if it's, is it windows? Is it buildings? Is it materials? If you can explain what's been broken or destroyed?
It's windows, it's a screen door, skirting, and they painted all over the side of a home and a shed.
Is this their lot 173 or is this other properties?
Other properties within the park.
And have you received complaints from other tenants regarding the behavior of those children?
Yes, I have.
And do you feel that in order to protect the integrity of the park, you need to have them leave so you can have a more safe and less turmoil in the environment there?
Absolutely.
Your Honor, I have no further questions.
Well, the problem is, just a minute, Mr. DeMeo, I'll give you a
Yes.
chance to speak.
Yes, sir.
You can't just throw some spaghetti up against the wall and hope it will stick. I don't know when, where, what was damaged, how old these kids are, whether they're 4 or 14. You filed a very poor notice to quit that says destruction of property. That is the only thing that they're on notice for, as to terminate their tenancy. That was in December 21st. There's no addendum, there's no attachment, there's no nothing. Then they get the notice to quit or the complaint, and it doesn't say anything. It just says notice to quit. So this is weak, and you need to have more specificity. They were agreeing to move voluntarily by the end of the month, but Mr. DeMeo was so disrespectful, he decided, screw it. So if you want to evict them, you got to do it right. You got to give me more than some vague allegations that somebody who did something to somebody. So you can either agree to let them move by the end of the month, or we can continue this for a proper hearing at a different date.
I don't want them to be homeless. If they're telling me they're going to move, I'll give them the concession and let them move by the end of the month.
All right, Mr. DeMeo, you got your hand up like we're in school, but I'll let you speak.
I apologize. I apologize, Your Honor.
Course.
I'm sorry. I didn't know you were still talking. I apologize.
All right, well, you agree to be out by April 30th.
Yes, Your Honor. I also like to comment on some of the things she was saying, because that's the things that you were saying about the. Yes, sir.
That's not going to help anything. All you're doing is making each other mad.
Well,
all I want to know is if you will agree to move voluntarily by the 30th of April.
yes, Your Honor, I will.
All right, now Miss Morse did a flyby. She showed up. I couldn't hear her. I don't know whether she could hear me. That doesn't count as an appearance. So she's subject to default. So you're making this decision for both of them. I told you at the beginning. Here she is again.
Your Honor,
Yeah.
there's somebody else. I'm sorry. It looks
He's
like
the
there's
next-
somebody else.
He's the next case.
Oh, okay.
We have several set for today. He's in
Oh.
dire straits too.
I apologize, Your Honor. I'm new to this whole Zoom court thing. This is my
Okay.
first time.
I told you, if you do reach a consent judgment with the court, you'd waive the rights listed above, but have the following additional rights. The judgment could not be enforced until 3 business days had passed. You could move to set aside this judgment within those 3 days if you misunderstood what you consented to or what you were waiving. Your motion to set aside the judgment will be set for a landlord-tenant hearing. However, if the judge does not find in your favor, the original judgment would stand. Ms. Morse, can you hear me? Ms. Morse? Instead of treating this like something important where she's about to be evicted from her house, she's treating it as an inconvenient nuisance that happens in the middle of her workday. So she's not here, and I guess we'll treat her as not appearing. Anyway, so if you agree on behalf of you and her to be out by April 30th, I will have Mr. Bush prepare a consent order for dismissal. If you don't move by that date, you're subject to being evicted on the very next day, May 1st. You understand?
I do understand, Your Honor, and I also wanted to say, like, with my meeting with legal aid later on, what do you suppose I do about that then? Like, if I talk to them and they say maybe, like I would really like to consult with them before I make a decision,
Well,
but like
3 days to move to set this aside if you misunderstood what you consented to.
Okay. So what you're saying is if I consent right now and then I talk to legal aid, I have 3 days to undo what I agreed to?
But you have 3 days to make a motion to undo what you.
Right.
Now, all right, I don't want to get jerked around. I don't want to jerk them around. They are
Right.
prepared to let you stay till the end of the week. Till the end of the month. I've already given you one adjournment. I'm going to be gone later in April. And so you need to tell me whether you agree to this or not. You can still talk to legal aid, and you can move to set it aside, but I'm not very inclined to do that. You told me you've got a place to move to on May 1st. This would not put another eviction on your or Miss Morse's record. And so you can still consult with them. But Miss Morse, can you hear me?
Yes, I can hear you now.
Do you agree to move by April 30th?
Yes, sir.
After hearing arguments from both sides, the judge ultimately chose a practical solution rather than an immediate eviction. The landlord's complaint was criticized for being too vague and lacking specific details regarding the alleged property damage. At the same time, the judge made it clear that the tenant's behavior during the proceedings did not help their position. In the end, both sides agreed to a voluntary move-out date of April 30th, allowing the tenants additional time to relocate while avoiding another eviction judgment on their record. The case serves as a reminder that courts expect clear evidence from landlords and respectful conduct from tenants. It also highlights how consent agreements can sometimes provide a middle ground when neither side gets everything they want. Who do you think handled this case better, the landlord, the tenants, or the judge? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.